had it kind of in the back of my head, but never thought about it seriously until a friend of mine mentioned, you would make a good judge. And we laughed about it, but then I started to really think about it then, and I started to apply once I left the Board of Aldermen. There were certain times when you had to delay things, to think things through, but what the lawyers want is they want a decision now. And you have to rule so they can know what to do next. Do they take you up on a writ? Do they move on? How do they change their strategies? That was really basically my philosophy. It was access to the courts, have your day in court, and I like trying cases, so I rarely would grant summary judgments or motions to dismiss on the civil side because I thought people should have a right to a trial. I think judges get in trouble when they make it about themselves, when they think everyone's watching them and hanging on every word. They really aren't. They want a decision. They want to have the perception that the system is fair. The biggest fear of a judge is looking stupid. And so I think when a judge lashes out, that's what it is. They perceive that the public or the litigants think that they're stupid. So it's very, very important to keep the temperament, keep the focus on the litigants and the parties, and don't make it about yourself. Once you get off into that, the temperament problems come in. I mean, I learned that if I was angry, it happened to me twice, I would leave the bench and take a break because I knew that if I was mad, I would make a decision. I knew it, that would be unfair, and it was really just vengeful towards the lawyer, not even the party. After about my 6th year on the bench, I realized just do not rule when you're angry. The best thing I loved about this circuit was the independence of the judges. Unlike other jurisdictions in the state, there were 31 different judges, and it was like 31 different countries. Now, it sounds like a setup for chaos, but in other jurisdictions, you would have the chief judge advising judges what they should be doing on certain types of cases or something. You would never have that in the city. And I think the reason you didn't have that in the city was because of the diversity, because everyone respected where everyone else came from and what their background was as far as their practice was and what they had done before they had come on the bench. I was proud that when I was in juvenile court, Judge Frawley had started the action of same-sex adoptions, and I continued that. I think it's more important now. I have 2 daughters that are gay, and I'm glad that I was a part of that. I think Judge Frawley and I were the only 2 judges east of Columbia that were doing these type of adoptions. I thought that they made a lot of families happy. We brought a lot of families together. We put a lot of foster care children into good families, same-sex couples. For litigants in front of judges, I would just say have a take, like come in with a clue as to what you want to do. So many times I see lawyers undecided or unprepared for the judge and will leave a vacuum for the judge to wade into instead of asking for what they really want. So I was raised in an area of the country where they elect the judges, especially in the urban, and it's a disaster because the judges are always getting in trouble because they aren't qualified. That is a 100% completely political process there that doesn't take into account the experience and the personality of the person. It's just they just insert someone on a ballot because someone in a back room said put them on there, or someone just started running for it. I think it gets tricky when you have a judge who is elected and is collecting money, raising money in order to run, and the litigants, the lawyers in front of them can give money. I think that's just a dangerous spot. So I think the Missouri plan is the best plan. I think you need to have something set up like they do that takes in the part of qualifications so you can balance the two. It was a murder case where a mother was slowly poisoning her 2 children through the use of clonidine, which was a blood pressure medicine. She was essentially stopping their heart, and she would show up to the emergency room at Children's Hospital, and really what it was just to gain attention. It was literally a Munchausen by proxy type case. We tried the case in 5 days, not one law enforcement witness, 50 witnesses, all of them medical personnel, doctors, nurses, pharmacists, nurses' aides. It was just a horrible case. The one child died a little boy of 10 years old. She was working on the other daughter, and they caught her in time. There was one juror that held out for murder in the first degree because she never imagined that a mother would ever do this to her children. So the jury came back with murder second degree, and I think I gave her like 163 years, consecutive sentences. And I think about that case all the time. I think about the doctor that almost quit the practice of medicine because he could not figure out what was going on. I think about her family that was convinced that she had never done this. I think about the boy, his sister who lived, and it was just an unbelievable case.